is and is not captured in recorded crime statistics. So in Scotland, national statistics on recorded crime are drawn from data captured by Police Scotland on the incidents that are reported to them that they then record as a crime. It's important to know that not all reports to Police Scotland will be recorded as a crime, and in fact, a large number of reports that come through the 999 and the 101 systems are not related to crimes at all. They may be related to calls for assistance for mental health reasons, they may be related to calls regarding small fires, and they may simply be something that the police don't necessarily deal with whatsoever. So things like calling about bins not being taken by the council at the right time. On the other side of this, not all crime is reported to the police either. And so the national statistics alone don't capture the full landscape of crime committed in Scotland. And in particular, crimes such as sexual assault and cybercrime are particularly underreported in Scotland. So to gain a fuller picture of the landscape of crime in Scotland, a number of other sources can be used that report on experiences of victimisation. And so we can look at sources such as the Scottish Crime and Justice Survey and the New Scottish Victimisation Survey. And these sources provide data on the extent and prevalence of crime in Scotland, including crimes that go unreported to the police, by focusing instead on self-reported experiences of victimisation.
So this is a good and timely question in Scotland. In terms of sentencing guidelines, those are devised by the Scottish Sentencing Council, which is an independent advisory body, a public body, that has a statutory basis in law. It's predominantly made up of the judiciary, so High Court judges, sheriffs, there's a defence lawyer, a justice of the peace, a prosecutor, there is usually a victims representative, a police representative, and a lay representative who has been an academic, and I should declare an interest at the moment, that's me. So I hold a public appointment to this public body, and we make sentencing guidelines. So one of the sentencing guidelines that the council has made is what's called the Sentencing Young People Guideline. It's received a lot of prominent attention in the few years that it's been in place. It applies since January 2022, I believe about the 26th of January 2022, and it was passed by the High Court. It's a sentencing guideline that applies to the sentencing of all young people in Scotland. The Scottish Sentencing Council commissioned considerable amounts of research, including with young people in the community, as well as young people who have had justice involvement, and young people in Pullman Prison, for example, and young people who are members of the wider community, as well as academic researchers looking at maturation, the development of the brain, and people's decision making when they are a child, when they're a young adult, and when they're an older adult. So the Scottish Sentencing Council decided that the definition of a young person for the purpose of this guideline would be people aged under 25 years old at the point that they pled guilty or were found guilty and are being sentenced. That's a relevant consideration because sometimes things, because of the court backlog, are happening months or years further down the track. So their age at that point is what's considered. The research and the public consultations, as well as the judicial consultations, turned up discussions of levels of maturity and how these can differ for young people compared to older people. That will not come as a surprise to our teaching colleagues. And they can also differ in ways that are affected by circumstance and by individual factors. The Young People Sentencing Guideline provides that rehabilitation is a primary consideration. There's another sentencing guideline called the Purposes and Principles of Sentencing. It could be rehabilitation, it could be condemnation or communication that an act was wrong, it could be punishment, it could be reparation or giving back to the community to make repairs. Out of those, rehabilitation is emphasised in sentencing young people. However, it's important to note that judicial independence and discretion is retained. This guideline does not ride roughshod over the capacity of a sheriff or a judge sentencing a person under 25 to consider all of the sentencing options. So if they want to impose a custodial sentence because that reflects the seriousness of the offence and various other factors, they can. There's nothing to stop them doing that. It can tend to mean, and the impact assessments show that it might mean more community sentences and disposals are imposed. It applies to all young people irrespective of crime type, so that's approximately 14,000 cases per year in Scotland. So it applies across the board. And I can also point out that there are interactive case studies, there's 3 short YouTube videos that have been commissioned, and lesson plans for modern studies. There's various resources in the Scottish Sentencing Council website if you'd like to explore these further.
This is about kind of the hierarchy of the courts and the legal system. So Scotland's Supreme Courts are the Court of Session for civil cases and the High Court of the Justiciary, colloquially known as the High Court for criminal cases. So Scotland has an interesting relationship with the Supreme Court in the UK. So the Supreme Court is the final court of appeal for civil cases in the UK, but not for criminal cases. So in Scotland, the High Court is Scotland's Supreme Court, whereas the Supreme Court will take criminal cases from England, Wales and Northern Ireland. In terms of the relationship with the European Court of Justice post-Brexit, so the European Court of Justice is officially called the Court of Justice of the European Union. It's the EU's highest legal authority. Post-Brexit, the European Court of Justice in general does not apply to the UK, but there are some exceptions and there are some cases ongoing. And while we're on the topic of other courts, the European Court of Human Rights is a separate institution and is not part of the EU. So that post-Brexit has remained unchanged.
So in terms of a guilty plea, this is a moderately straightforward question to answer in some respects. So does a guilty plea affect the sentence imposed? I can say with confidence, yes, it is taken into account in sentencing. Judicial independence and discretion still exists. It's not fully constrained, but the Criminal Procedure Scotland Act in 1995 provides that the court must take into account the stage of proceedings at which and the circumstances in which an offender has indicated their intention to plead guilty. So in the sentencing process guideline, it sets out in very neat steps and in one table the exact process that the judiciary follow across Scotland in the sentencing process. Prior to considerations of the affect of a plea of guilty, they consider things like the seriousness of the offence by looking at culpability of the offender and the harm caused, or in some cases which might have been caused, and identifying things like mitigating and aggravating factors. But if a person has pled guilty at an early stage, thereby averting the need for a trial, for time and administrative costs of the court, and for the time and likely distress of victims and witnesses, as well as the time of professionals that it would take to go to trial, that is taken into consideration at the point of sentencing. That consideration often leads to the court applying what's called a discount to the headline sentence. So it might be common to hear a member of the judiciary saying, I sentence you to 2 years of custodial sentence, reduced by 3 months to this. So that's a sentence discount being applied. Or if it was the most common supervised order in the community, a community payback order, they might have a recognition of certain amount of unpaid work or community service hours reduced as a recognition that they pled guilty at an early stage. The other factor that's taken into account is whether they've already spent time in custody, remanded in prison in the sentencing process, but that doesn't apply in all cases because bail is fairly widely used. So plea of guilty is one of the considerations in sentencing.
What is corroboration? So corroboration is a requirement of Scots law that there must be two separate sources of evidence against a suspect before a case can proceed to trial. This doesn't mean that there needs to be two separate witnesses, rather that there need to be two separate sources of evidence. And those sources of evidence are quite wide-ranging. They can include digital evidence, such as CCTV, victim statements, police statements, eyewitness accounts, photographs of injuries, forensic evidence, such as DNA, the accused's interview statement, and circumstantial evidence such as the accused's behaviour following a crime. Corroboration can be a contentious aspect of Scots law. It does seek to protect the accused from being convicted of a crime based only on one source or one bit of evidence, but it's therefore problematic for crimes that are committed in private settings, where it is likely that there will be only the victim's account of what happened and where other evidence may not be available.
So, in terms of transgender people in prison and what's the situation with that, it's important to say that there's only 15 transgender prisoners in Scotland as of December 22, and that kind of leads to the lack of research into the experiences of those transgender prisoners, meaning that there's very minimal understanding of what the treatment of those prisoners looks like versus the official policy guidance that is applied. But there is a guidance that exists, and that has been created by the Scottish Prison Service in 2014, and that's the Gender Identity and Gender Reassignment Policy. And this policy details the procedures for initial reception to custody, decisions for transfers between prisons, prison housing, and the treatment of current prisoners who identify as transgender. So in terms of the initial reception to custody and the decisions about the transgender prisoners' allocation to prisons, the policy generally states that the accommodation provided must be suitable to the person's needs, reflecting the gender in which the person is currently living. And crucially, the one key aspect is that not having undergone gender reassignment surgery is not generally treated as a factor that should determine the allocation to prison. However, there are some cases in which individuals might be placed in establishments that do not correspond with their gender identity for a variety of reasons, and those include lack of sufficient information at initial reception to custody or issues of safety to themselves or others. But the policy also explicitly states that, for example, transgender women should not be automatically treated as potential risk to other female prisoners, which is often reported like that in the media. All the decisions about the allocation to appropriate establishment are done during a gender reassignment case conference, and unit managers are also obliged to conduct a risk assessment associated with allocation to prison. In terms of kind of the treatment and the lives of the prisoners, the transgender prisoners in prisons, the policy states that they should be allowed access to items that allow them to express their gender identity, for example, clothing, makeup, and they should have access to appropriate healthcare, which includes hormone treatment, as well as gender clinics and therapy for those who want to start their transition while in prisons. As everyone probably knows, the issue of transgender prisoners is a highly controversial one, and it brings attention of a lot of politicians and the media and general public. And most recently, there was a case of Isla Bryson, who was convicted of sexual offences and was initially placed in Corton Vale. And this led to a review of the management of transgender prisons by the Scottish government. And the review concluded that at any point, women were not at risk of harm from the transgender person in custody, and that she did not come into contact with any prisoners, and that the policy that was kind of mentioned above was followed during all the steps of the decision-making process and risk assessment. But it's worth just having a look at those policies to kind of familiarize yourself, because there's a lot of more information available there. And in terms of the situation of pregnant people in custody, Similarly to the issue of transgender prisoners, there is a very limited research into the experiences of those in Scotland, and the majority of that data tends to come from England. But according to SPS, pregnancy should be taken into consideration when determining their residential location, and there are mother and baby units available in prisons where pregnant prisoners can be referred to. Additionally, individual birth plans are developed for all individuals that are expected to give birth, and they should be under the care and supervision of an NHS midwife. Further, meals are amended and supplemented with consideration of their nutritional requirements. Pregnant individuals are provided with additional clothing that they may require. And those expected to give birth in custody are provided with mother and baby bags that they can take to prisons and to hospitals, and this includes clothing, provisions for the mother and the child during the stay in a hospital, including nightwear, supply of clothing, bathing, and changing materials. But despite those provisions that are put in place, the Scottish Government's report that focus on physical healthcare needs of the Scottish prison population mentions that there is still very little data available regarding pregnancy, maternal health, and postnatal care in prisons. Some more information can be accessed from, for example, 2016 Rose Project report, which offers some insights into the improvements that are needed in terms of care offered to pregnant prisoners. And this, for example, includes the increased need for access to skilled professionals. And as there is a limited research available in Scotland, we can look towards the English prisons and the research done on those. And some insights from that research say that pregnant people tend to experience stress, worry, hunger, and exhaustion during their stay in prisons. There tends to be lack of information for first-time mothers about becoming a mother and about labor and the whole process, which they tend to take from other prisoners. There's also a lack of clarity about the rights to apply for the mother and baby units, as well as the conditions of the maternity leave for those that undertake some paid work in prisons.
Okay, I'm going to talk to you today about the female prison estate, in particular the new community custody units. So, as we know, men and women tend to commit different crimes, and there's strong evidence to show that the justice system should tailor their approach to women in a system that was originally designed by those in power at the time who were predominantly male. Whilst the prison can have a negative impact on everyone, the challenges posed by prisons are often felt more acutely by women. Over the years, there have been a number of reports and publication on what works for women in the justice system, such as A Safer Way in 1998, the Corstron Report in 2007, and the Commission on Women Offenders, also known as the Angiolini Report, in 2012. There have been calls for reducing the number of women sent to prison, as well as for them to be given community sentences, which helps to reduce the damage caused by a custodial sentence. For example, women are often sent to prisons quite far away from their homes, meaning that they could lose contact with their family, possibly lose custody of their children, and have their lives disrupted in many harmful ways. So if we look at the Scottish context, A Safer Way followed a tragic spate of deaths by suicide in HMP Corton Vale in the late 90s. This report concluded that HMP Corton Vale was not fit for purpose, and that the number of women held in custody there should be reduced to 100. But if we look at the latest Scottish Prison Service custody figures, we can see that there are currently 305 women in prison throughout Scotland. So we're 25 years down the line and we've still not met this target. Despite reports such as A Safer Way and many more like it, in 2012, the Scottish Government actually announced a new super prison in Greenock called HMP Inverclyde, which had a capacity for 300 women. Incidentally, that was the same year that the Commission on Women Offenders by Dame Eilish Angiolini was published, which called for many radical reforms for women in the justice system due to the treatment they were receiving in the system, which was actually causing them harm and trauma. Plans for HMP Inverclyde were actually scrapped in 2015, which was a huge victory for justice campaigners and provided hope that the future for justice-involved women would follow existing research on what works. Alongside the scrapping of Inverclyde, it was also announced that Corton Vale would be demolished and a new prison with a capacity of 80 would be built on the same site, which is currently happening. In the Commission on Women Offenders, Angelina made numerous recommendations to improve women's experience of the justice system, which included that she said, this quote was on page 66 of the report. She said, Corton Vale is replaced with a smaller specialist prison for those women offenders serving a statutory defined long-term sentence and those who present a significant risk to the public. Additional places for women offenders should be provided in local prisons to enable improved community reintegration and family contact. So these local prisons were meant to house the majority of women in custody with the idea of keeping closer community contact and to improve reintegration into society upon release. The locations for these local prisons were to be spread throughout Scotland, and in 2017, the then Justice Secretary Michael Matheson announced plans for 5 community custody units, which obviously were to do just that. So community custody units, or CCUs, are Scotland's newest form of prison. They are smaller units for women, and despite original plans for 5, there are currently only 2. One in Dundee for 16 women, called the Bella Centre, and one in Maryhill, Glasgow for 24 women, called the Lilia Centre, both of which opened in late 2022. So what makes the CCUs different from traditional prisons? The ethos behind the CCUs is heavily based on Angelina's recommendations and purports to support women towards independence through access to important services inside as well as outside in the community. The women will also be encouraged to have a level of autonomy over themselves by playing an active role in their own support plan and working closely with staff. The women will have access to recovery groups inside the CCUs, and there will be a focus on wellbeing activities such as yoga. And some women who have a place in the CCU will also have community access, which would hopefully help their reintegration upon their release. So it's important to say it's still early days for the CCUs, with the women only being moved into them late last year. And information regarding the allocation criteria is not currently available from the SPS. However, having visited the Lilia Centre myself, I can say that it's unlike any traditional prison in Scotland. The physical environment is more reminiscent of, like an art market dentist or her doctor's surgery, lots of pastel colours, wooden accents. The visitors area has a kitchen where women can cook with their families. There's a garden with a play area for their children. Instead of cell blocks, there are houses which contain mini studios where each woman has their own bedroom with an ensuite, as well as access to a communal kitchen and living area. So on paper, the CCUs are definitely a marked improvement on traditional prisons, but it remains to be seen how successful they'll be in practice, with many questions being raised over things like allocation, risk of community access, and how to navigate communal living. As we know, the majority of women in prison have poor mental health and have experienced a high level of trauma throughout their lives. The ethos and design of the CCUs claims to be trauma-informed to help address the needs of women, but only time will tell whether these new forms of prisons will actually be successful in this space.
So does motive matter? This is a very quick answer. In Scots law, as in other jurisdictions, legally motive does not matter. Legally motive is irrelevant. What is relevant to the law is intention and mens rea. It's the intention of the accused person, not motive.
Okay, the criminal justice system, a brief overview. So I think one of the kind of starting points for people when they're thinking about the Scottish criminal justice system is to think about whether it is distinctive, usually from England and Wales, or not, as well as maybe documenting different parts of the system and how they've changed, etc. And while that is an interesting question, obviously everything really does exist in relation to something else. Others may also argue legitimately that British criminal justice can tell a story about itself without always having to be something in relation to England and Wales. But what we can say about Scottish criminal justice then is that it has developed independently from the rest of the UK for well over 300 years. It's really based on its own legal system and institutions. It's not something which magically just became different from the rest of the UK with devolution in 1999. However, with devolution and the creation of the Scottish Parliament, the room for divergence or for a kind of unique, different approach in criminal justice certainly increased because we gained more powers. And while we see that in some parts of the system, many other parts of the system do look very much the same. or at least similar to the justice system in England and Wales. In terms of things which are maybe particularly unique about criminal justice in Scotland, people often refer to the children's hearing system, which is sort of the jewel in the crown, if you like, of Scottish criminal justice. People talk about it with great pride. And I think more widely, the approach to youth justice in Scotland is also something that people are quite proud of. Also, the probation system, which is based in social work rather than kind of separately and potentially more kind of punitively based. We have a police service which is orientated towards safety and well-being. That's supposed to be the primary function of police in Scotland. We've also got a far lesser role for privatised services in Scotland than in the rest of the UK. On the other side, though, we can see things which are maybe, which we can be less proud of, if you like. And here we can certainly think about the rate of punishment that we have in Scotland, both rates of imprisonment, which is the highest in Western Europe, but also of community punishment. And this has been the subject of a lot of good scholarship from the SCCJR over recent years. So people tend to only think about the rate of imprisonment when we're thinking about how often or the kind of frequency at which a nation punishes, but we shouldn't forget about community punishment as well. That's important too. And on both of those metrics, Scotland punishes very highly in comparison with our Western European neighbours. And one of the things that's maybe interesting to think about when we're thinking about Scottish criminal justice is to be a bit critical about this idea of, or treat, but at least interrogate it a little bit, this idea of penal welfarism. And that term means that we've got a penal system of criminal punishment, which is underpinned by principles of welfarism. And while we might think that's a good thing, because we want to think about if we are going to punish people, then we want to do that with their kind of welfare in mind. That sounds like a good thing. But the unintended consequence of that could be that we're just drawing more people into the system in order to provide them with welfare. And recently there's been quite a lot of work which is kind of drawing attention to the way that these forces can be working in Scotland. In terms of overall challenges which the criminal justice system in Scotland is now facing, apologies, these points aren't on the slide, there are certainly very significant challenges around budgetary pressures, and this is following the recent round of cuts, which we don't know yet, but they could be as devastating as austerity following 2008. We'll see, but certainly there are real and significant pressures in the justice system in Scotland at the moment. There's also, I think, big questions around coordination and efficiency within the justice system. Now, the justice system is called a system, which implies sort of coordination between the different parts. Often it doesn't really operate like that very effectively at all. So there's questions about coordination and efficiency between the different parts of the justice system, but also I think within parts of the justice, within kind of discrete parts of the justice system as well. There can be, we can raise questions about a lack of coordination and efficiency. And this is in a nation, Scotland, which isn't particularly big, but historically these things have kind of been allowed to exist, and it's difficult to change them. I think there's also real tensions in our justice system between a desire to see criminal justice or to see crime and punishment as a kind of public health problem, and therefore to attend to the causes or the ways in which we respond to these problems, much more kind of focused on the causes of them. So between that on one hand, and then on the other hand, between a much more kind of reactionary response, which maybe sees justice in a more kind of punitive way. And arguably you have this tension in probably all criminal justice systems, but I think in Scotland at the moment, this kind of tension is particularly pronounced. And we see the way that justice is spoken about as being quite kind of using words relating to welfare and public health responses, etc. But potentially the way that that's experienced by people in the system is quite different entirely. And finally, I think it's just worth noting that the criminal justice system in Scotland, as elsewhere, really very often is responding to social problems. Be that matters of social inequality according to different matrices, different ways of measuring social inequality, or if it's other social problems such as gender inequality or whatever. And really, if we're thinking about, if we're thinking about improving criminal justice in Scotland, we need to think about fixing those other kind of problems first. Okay, the Parole Board for Scotland, the simple answer is that their role is to decide when people serving certain sentences can be released from prison into the community. And it's not all sentences, they've just got this role for some sentences. And these are determinate and extended sentences of 4 years or more. And also indeterminate life sentences. And in all of those types of sentences, the board also has a role in deciding the conditions of the licenses that these people will still be subject to in the community. And the board also has a role in deciding if somebody should be recalled to prison if their license conditions are deemed to have been breached. Now, Parole Board Scotland is a judicial body, it says so on its website, but arguably there's some debate about what that really means in practice. Everybody would argue that it has judicial functions, but some argue that that means it should operate like a criminal court. I would disagree with that view, but that's certainly a kind of slightly contested question at the moment, or at least operate more like a court. But what it does certainly is that it adjudicates on matters of detention and release from prison based on evidence and underpinned by legislation. So each case is considered by members of the board, and each case is convened by somebody with a legal background, although there are also lay members of the board as well. So Parole Board Scotland, or parole processes, are not supposed to be concerned with punishment or deterrence, which are principles of punishment which a court will bear in mind, but instead to be focused exclusively on questions of risk and risk management. So the board's role is only to decide if somebody is safe to be released from custody into the community, or and the conditions under which they should live in the community while still under license, and whether their risk is so great that they should be recalled back into custody. But of course, thinking about this from the perspective of the person whose case is being considered, or who is serving a sentence under license, whether they are recalled to prison or whether they are able to be released from prison or not, is actually that those questions simply extend their punishment in prison. So whether it's about risk or risk management, for them is kind of immaterial. The result of the decisions about risk will potentially result in more punishment or not. There's also real questions about the role that victims and the wider public should play in parole processes at the moment. And we've seen this in Scotland to some degrees. And again, these questions are not unique to Scotland at all. We see them probably playing out more loudly in England and Wales as well. And then further afield in places like Scotland, it's way more extreme in terms of the role that public and indeed politicians can play in parole processes. So in Scotland, over recent years, there's been a lot of discussion around these questions, springing from probably quite legitimate concerns about the victims' experiences of the justice system, and particularly in around parole processes, around the information that they have and the support that they receive when somebody is about to be released from prison. But some of those kind of debates have really been combined with wider debates about, which are maybe more kind of populist in tone, about what right the public have and what role they should play, and indeed what role the victim should play in deciding whether or not somebody should be released. So yes, we've seen some changes in these matters in Scotland over recent years, and now victims are allowed to attend some hearings that they are relating to a case that they have been involved in, although they're not allowed to input into those, their tribunals. Actually, they're not allowed to input into them directly. So yes, that's one of the things that's kind of changed over recent years, and there's kind of ongoing questions and concerns about. Okay, finally, you'll all be happy to know this is the last question. Are open prisons still used in Scotland? The answer is yes, they are, but I think most of my colleagues would say not enough. So we have one open prison in Scotland, which is Castle Huntly, and we've also got 3 national top end units, NTEs. And the national top end units sit within other closed prisons. So Castle Huntly, the overall objective of both the open prison and the national top end units are to support people in their reintegration back into the community. So when people have been spending a long time in prison, it can be very difficult actually to leave prison and to reintegrate successfully and happily back into the community. And these different prisons are designed to support them in that process. So Castle Huntly allows people unsupervised leave into the community for a day release, such as in order to allow them the opportunity to work, for example, or visit family. And the national top end units allow some supervised leave. Now, I said at the start there that these prisons aren't used enough, or Castle Huntly certainly isn't used enough. It's currently sitting at only 50% capacity at the moment. And this is at the same time as other prisons, such as Barlinnie, for example, is very overcrowded. So Barlinnie is now at 130%, which is the highest it's been for a wee while. So there are questions, I think, about why our one open prison in Scotland is sitting at half capacity while other prisons are so overcrowded. And that really is because of problems that we have in Scotland relating to progression within the sentence, within the prison sentence. So that means prison sentences are not just one block of time. sometimes it can maybe feel like that for people serving long sentences, but there are certain points that you need to get to in order to progress to the next part of your sentence. And then towards the end of that, you can get to the national top end, and then after that, maybe Castle Huntly. And in order to kind of meet these certain points and progress past them, you very often need to complete a so-called behavioural change programme. And these are kind of psychological-based rehabilitation programmes in prison. And there are real problems with accessing these in Scotland at the moment, and these problems have been really exacerbated quite acutely by the pandemic. So that's one of the reasons why we don't use Castle Huntly nearly as much as we should. There are also, I think, questions about its underuse relating to just our appetite in Scotland for much more flexible types of sentences. So in other countries, notably our Scandinavian neighbours, which are often cited, they make a lot more use of sentences where people are allowed periods of home leave within their sentence, and that allows them to maintain links with their community, which are so important for reintegration.